All right. Hi, everyone. This is Curt and welcome to another edition of Fire Law Roundup, this time for September 26th of 2022. And with me, I've got Bill Maccarone. Brad is actually in Paris. He just texted me this morning, kind of giving me the business, but he's over in Paris. And so we got Bill Maccarone here. And Bill, interesting week. I don't know. We got 5 stories. Which any of them stand out to you?
Well, they're all pretty interesting. Obviously, political. The "Let's Go Brandon" T-shirt, the one from last night was, that I was reading that last night and was, I can see that happening.
Yeah, well, let me just jump in first and just mention a couple of folks have written to me asking, was I aware of the Walmart fire? The lawsuit litigation leading out of the Walmart fire in I think it was Plainfield, Indiana. Yes, I am. I was aware of the fire, and I'm aware of the status of the case right now. So, and I may be blogging about it just because I've gotten so many emails about it. But the status of that case is that a lawsuit has not been filed yet. When you're going to sue a municipality, you have to notify them, and every state's slightly different here, but you got to notify them within so many days. Could be 90 days, could be 6 months, could be a year, but within a certain period of time after the incident occurs, the harm occurs, if you plan to sue government, you got to put them on notice of your claims. So that's the status of where that suit is. There's somewhere over 30 fire departments that responded. The owners of the facility ended up filing those complaints to preserve their rights. And I believe that they're investigating. So whether or not it will result in a lawsuit, well, it's probably going to result in a lawsuit. Now, whether it's going to result in a lawsuit against all of those communities or some of those communities or none of those communities, maybe they're going to go in a different direction. Who knows? All we know is that the civil claims have been filed, and we'll kind of keep an eye on that. Now, Bill, I don't know if you.
I did. I was reading about that. I guess it was about a week and a half ago. It was last week that I was reading about that. And what I was struck by was the number of potential defendants. And I looked at, and that was what really raised my, because I initially was like, oh, looks like there's a lawsuit coming out, and then I saw the number of potential defendants and said, wait a minute, and then realizing exactly as you said, because my first glance was thinking that there's litigation, has been filed, that it is happening. But then and looking at it deeper, realized there was, basically putting the municipalities on notice, et cetera. But that had to be, I remember seeing on the news, but that had to be just an incredible fire to have, all those departments and all those, it's enormous building.
These buildings are just enormous, and they pose enormous fire problems. I know when I was back with the NFPA, and I forget if it was 2008 or 2009, but I wrote an article in Firehouse about these mega warehouse fires. And there's so much money that's tied up, hundreds of millions, if not billions of dollars tied up in these warehouses, because number one, they're not your typical warehouses. They're exponentially larger. They have much larger inventory, so that when they burn down, there's a much bigger loss. And whenever there's a big loss like that, the insurance companies are looking for some outlet to recoup some of the money that they're going to lose. That's sort of problem number one. Problem number two is these buildings pose some incredible fire problems. They have rack storage, and the sprinkler systems are designed to contain a fire. And if you think about it, this was as it was explained to me at the NFPA. And I know we're getting a little off law, but you and I love to talk fire anyway, so we'll talk fire. But when you think about sprinklers are designed not to put out a fire. Okay, now they can design a sprinkler to put out a fire, but that's not the purpose of the sprinkler. The sprinkler is designed to hold the fire in check long enough for the fire department to come in. Now, you think about a house or like a drugstore or maybe a hardware store, that might make sense. You're going to hold the fire in check. But now you have these buildings that are like one huge room. Okay, so that the fire has access to this enormous room, 1 million square foot room, with rack storage that is 50, 60, 75 feet high. And you have a fire somewhere in there. And you have sprinklers that are not designed to extinguish. And again, they could be designed to extinguish, but they've got to have much more water, all different properties. But they're designed to hold it in check. And now you have a fire department that, and I don't think anyone has a fire department that is trained and able to get in there and extinguish one of these types of buildings. They just pose so many hazards, risk to firefighter safety as well. Because some of these, there was the one I wrote about back in 2008. The fire department actually got in there. They could not get the ladders in the aisles, because you're trying to get a 50-foot ladder up inside a building, and the angle that the ladders were at, they could not get up there. There was literally no manual way to put the fire out, and they shut the sprinklers off in that incident. It burned the building down, and we're back to square one again. And it sounds like that's exactly what happened in Plainfield. So.
Very often they build these factories in rural areas too, where there's that limited water supply, limited staffing, so many different limitations.
Yeah, well, I've done some work for them. They're a good department, and they're right around a number of our friends in that area. You're and my friends, and we don't have to name them, but that we have a number of colleagues that we've come to meet over the years, and good friends that we socialize with in that area as well. So that there's not to slight any of those departments.
No.
The one that I spoke about before, I believe it was in South Carolina, was a small town, as you suggest.
Mm-hmm.
They actually called for career firefighters from some of the cities. I think it was Columbia or Charleston, sent career firefighters in, because it was a volunteer department. And they ran into the same problem. So these buildings are not designed to be able to withstand a fire. Certain fires, yes, but the sprinklers are not designed to extinguish the fire, and manually you just can't get to where the fire is burning. And it's I think the best you can hope to do is hold it in check until it runs out of fuel. But at any rate, let's get back to law. Our other love besides firefighting, but the legal procedure for the case right now it's at the claim stage. They've got to let the communities consider the claims for a certain period of time, and then if the community either denies the claims or doesn't act on the claims, then it can go to court. So that's sort of the status where we're at there. Okay, so, and that wasn't even one of last week's stories. So, but it's certainly, and I may blog about it tonight and just elaborate a little bit on that. So, but let's you want to start with Let's Go Brandon?
Why not?
All right. Well, the first case is out of San Francisco, and really brief case. I mean, there's a firefighter who apparently was wearing a non-regulation T-shirt. And again, we don't know. It could be that it's photoshopped, or who knows. Somebody put a sticker on his back and he wasn't looking. That would never happen in the firehouse, right? No one would ever put something on someone's back, especially not to get them in trouble. But at any rate, he ends up with a shirt that apparently on the back, on the shoulder blades of the shirt, says "Let's Go Brandon," and someone apparently got a picture of it and then posted it on Twitter and tagged the mayor, one of the city supervisors, and the fire department with the question: "Is this the new official uniform of the San Francisco Fire Department?" So he's under investigation. Not good.
Yeah.
So
I imagine that was one of those phone calls with the fire chief got from the, it looked like the date on it was the 24th. So if it was on a Saturday, that, when the fire chief, when his or her phone rings at 3 p.m. on a Saturday, and it's the city manager or it's never a good thing, right?
It's almost like as a fire chief, you almost don't want to watch the news, right? You kind of, do I want to watch the news, or do I want to open the newspaper? I don't know if anybody actually gets the newspaper anymore, but we used to be kind of like, oh boy, what's on the front page this morning, and this is not good. So, couple of things. A couple of folks had reached out after I posted this one, and so one of the posts suggested that maybe the officer bears more responsibility than the firefighter. I think it's going to come down to the policy. Does the department have a clear policy on what's acceptable without regard to the political content of it? And it's the same thing. I mean, you can't allow other types of political sentiments that go to the other end of the spectrum to be warned and then try to stop this. So you've got to make sure you have a policy and then that it's consistently enforced. It's not just enforced against people who think along the way that this firefighter does. It's got to be enforced consistently. So.
And that's probably the biggest challenge in that type of situation. Very often, it's very, very often the policy will be in place. There'll be something somewhere, right? And then, but how do we approach that? And that's just that's the facts we have. That's kind of how it typically goes.
Yeah, it's got to be enforced consistently, or if you're allowing one political sentiment to be expressed and not another political sentiment, now you find yourself in a prior restraint or a First Amendment challenge.
Absolutely.
Yeah, absolutely. So the best bet is, wear your uniform and only your uniform.
Absolutely.
All right. Oh boy, lemon law. I've seen lemon law cases. I don't know, Bill, you want to take us through this one?
Yeah, absolutely. Just from the facts as they're laid out here, is a fire department. Actually, I think it's a fire protection district in Illinois that purchased a couple of Seagrave fire engines, a pumper and a tower ladder. They had a series of problems or a number of issues with the tower ladder, and it led the department to basically return it, or to say, hey, enough is enough. There was some safety issues. There was some issues with hydraulics, claims of hydraulic fluid leaking, and different, very much not just paint chipping or something along those lines. Something that was definitely a safety type of issue. And they went to Seagrave and said, listen, we want our money back. Which tower ladder? It looks like it's around $1.4 million. So it's not it's just unbelievable the expense of these things these days.
If you can get them.
And that's the other thing. They probably waited 2.5 years to get the thing. But basically they the city or the district ended up employing counsel to say, hey, let's take all legal actions that we can to get our money back and return this thing. And now it's pending. So it'd be interesting to see. I think a lot of times these and you have the data, Curt, you deal with these things all the time. They're not uncommon, but they're not as common as I would expect they should. I think a lot of times we don't do a great job as organizations kind of like tracking these things through and maintaining a record like this. And maybe that's just my take on it, but I think there's probably more instances out there like this that aren't, making their ways to the courts as far as those, these types of problems or claims that arise.
Our lemon law here in Rhode Island excludes commercial vehicles. Doesn't cover commercial vehicles.
See, I never knew that. Okay.
Yeah. So that wouldn't even be an issue in some states. Apparently, I didn't take the extra step and go actually research the Illinois law on that. But they're also alleging breach of warranty and breach of contract. So even if the lemon law part of the case fails, it wouldn't apply. Okay. Boy, it's not, certainly when the legislature enacted the lemon law, I don't think they were thinking about $1.4 million tower ladders. They were thinking about somebody buying a Toyota or.
No, you're right. A used car or a new car. Yeah, you're absolutely right.
So, yeah. All right. Next case here. We've got a settlement of a suit in New York, upstate New York. Again, kind of hard to figure out exactly what was happening here. Bill, any insights on this?
No, I wish we had a New York attorney to kind of help us out, but he's in Paris.
Again, she had a shoulder injury. She tried to come back. Apparently, that didn't that didn't pan out. She went back off on disability. So she had the injury, she had surgery, she had PT, she comes back, she goes to light duty for a period of time, then she returns to full duty briefly before going off injured. So in my experience, that's a fairly common occurrence, especially with shoulder injuries, male or female. We see shoulder injuries being problematic. But she came back, she tried to have surgery, and she wasn't able to go back to full duty. She applied at that point for disability benefits, and she was apparently turned down. And then she was terminated because they felt that she was not being, I'm assuming, forthright, that she was engaging in physical activities that were not consistent with her disability. Again, my experience, something that we do see from time to time. And but at the end of the day, her attorney argued that yes, she engaged in those activities, but they were consistent with her medical condition and not inconsistent with her being able to or being unable to perform her duties as a firefighter. And she was in the process of appealing her termination as well as suing for disability benefits. And this was sort of a global sentiment. It looks like she did end up getting some sort of a pension. It was a reduced pension, but she did get some sort of a pension and disability, I believe, not a line of duty disability, but she did end up getting a pension. And so this was basically a cash settlement, $25,000, which probably, I'm assuming, is lawyer fees, and she ends up with her disability. So
disability or pension, yeah. And I think another important, very often, I think, and I've seen this in real life situations where folks get, so you get hung up on, well, the person is bicycling, and obviously that's a physical type activity. But very often it's not a very high impact type of activity. So it's a terrific activity to rehab. It's a terrific activity, and every situation is different. This, but as a general rule, bicycling can be a very good thing to be doing when you're out injured, disability, preparing to come back to work to keep your stamina up and your physical fitness. And it's not a high impact type of a thing. So,
right.
But sometimes they seize on folks will seize on things like that as a this person is fraudulently claiming an injury. So it all depends on the facts, obviously, and every situation is a little different.
Yep.
These are tough cases. These are tough. It's tough to wrap your head around.
They are, and they're unfortunate. They're unfortunately all too common. The how two people my close play at second base metaphor there, but two people can look at the same situation and say, that's fraud. Oh no, that's legitimate. And so it's sort of creates that situation for reasonable minds to differ on the facts. And but in this case, we're talking about at least two lawsuits now being settled. And I'm amazed that we find ourselves where certain people are associated with a large number of lawsuits. That it's not spread across everyone, that some people almost seem to just find themselves involved in a lot of different litigation. So, but next one's also New York. Wow, where is Brad? Yeah, he's in Paris, France. He's eating a croissant in some bistro, right in Paris with his wife. But at any rate, he texted me this morning, so he's torturing me. But but we've got a volunteer firefighter who's alleging that his dismissal violates his civil rights. So, you want to?
When I looked at this, and actually I found a relationship between this New York case and the airport firefighters. And the analogy that we'll talk about in a few minutes here, I think the analogy I drew was the analogy you use in your discipline class with chasing the rabbit.
Mhm.
right? And that's kind of it. You can almost see that in these types of situations. Here, you had
Mhm.
a volunteer firefighter in New York, Long Island, I believe is where Comac is.
Mhm.
And essentially, there's an allegation, or at least charges, that this individual had run for an officer position in the organization, and as a result, maybe had people didn't like him that much, at least his claims are, and he was hailed in for missing a couple of trainings. And it sounds like, at least based upon the complaint, which is always going to sound good for the complainer, but it sounds like that the individual, the gentleman, had a reasonable excuse to say, I'm an ICU nurse or a critical care nurse in the COVID pandemic, and unfortunately, he missed some trainings, and as a result, they were moving. The department was moving to, have him removed from the roles and taken off of that status. So it almost, at least also according to the complaint, the firefighter said, listen, let me just withdraw under good standing. Maybe I don't have the time for this right now, so let me back out. I've been here for, I think it was 15 years. It was a long, 15 years of service. So it was not a flash in the pan. This, person's been there for a while. And basically, he went to the board and said, let me kind of back out and withdraw as a member of good standing. I'm assuming that allows you to come back at a later date, a little easier probably, and, get you back in when you have the time. And part of what you have to shake your head on, again, it's just the allegations, but the organization, the board that runs that executive committee, refused to accept his request to step back from everything and take that kind of a leave, and instead move to have him actually removed from the roles as a member and not in good standing. And I think that sometimes you really have to, from the 30,000-foot view, you have to say, really, does that make a big difference for the board? At this point, aren't you kind of getting, even if you don't want the person there, even if the person's a pain in the neck, even if the person, they're saying they don't have time, let them kind of fade off. I mean, why do we have to draw this line in the sand, invisible line in the sand? That's my take on it. That just, you're chasing the rabbit. You're not looking at the big picture. You're focused in on the fact that maybe you got a problem with this individual. And sometimes the problem's, sometimes it's not unfounded, that problem, but you have to look at the bigger picture. That was my takeaway. I don't know.
I look at them, sometimes we have a problem employee or volunteer. They're a pain in the butt. Okay. Sometimes we have people in the fire department administration that are the problem. They're the pain in the butt. Okay. And sometimes we have both combined. Okay. So whenever I look at a case, I'm trying to figure that out. Is it just the problem employee who's filing the suit? Is it a sort of a dysfunctional sort of structure within the fire department? Do we have both? Or is this just one of those things that happens from time to time? Well, let me ask you this, Bill. How many federal court lawsuits have you ever filed for yourself in your lifetime?
None.
How many have I filed? None. Okay. What would it take for you to be willing to file a federal court lawsuit over one of the many activities that you're involved in? But something led this person to file a lawsuit in federal court over this. Not that they don't have a right to, but I don't know. For a volunteer activity, it just seems like a lot. And for those of you who aren't familiar with federal court, you're looking at, I don't know, last numbers I've heard is somewhere between $150,000 and $250,000 to, successfully bring a case to trial in federal court. Most attorneys, they're not going to take a case like this pro bono or just for expenses. So there's some money on the table here, and whether that's worth it, that's an individual decision, but not your typical case that we see here.
No.
Okay. All right, and let's get the story that really I'm really surprised at the number of shares and likes and conversations that this case has created, and commentary as well in social media, but. This is the Washington, D.C. Metro area professional firefighters. They cover Reagan and Dulles, the crash fire there. And Bill, you want to, I'm retired. So, but you're still in the IAFF. So why don't you give us the IAFF perspective on,
Well,
on this? Have you been to the annual conference? Have you been to the,
the buy-in? Yes, I've been,
yeah.
I've been to the IAFF conference before. I was back, I'm gonna say probably late 2008, maybe 2010. I was in Las Vegas. And I've been on the floor when we've done these resolutions and we've had these censures. Which
so
is a little bit
walk us through it.
Yeah, well, a local can go and the local can basically petition the IAFF for a censure. And what it is it's only 30 seconds of time on the floor, and all these local presidents or representatives will get up, and the executive board that's up in the front of the hall there they'll read a proclamation of basic resolution stating what the issues are with this particular fire chief or city manager or whatever the case may be. And it's typically not just the typical run-of-the-mill stuff. It's the things that are like, refusal to bargain or, refusal to recognize the union, et cetera. And they'll censure them. And the way I always understood it, and I was told by quite a few folks on the IAFF side, there are many folks, fire chiefs and city managers, that kind of wear that as a badge of honor. Like that, this, the union doesn't like me.
That's unfortunate,
this shows that the union doesn't like me. But, and that's at least something that I've been told before, because obviously in the best situation, you have a good relationship between both sides. Granted, management has their job to do, labor has their job to do, but at the end of the day, you try to, you be reasonable and find that middle ground. Here, there was a censure that went up at the most recent convention up, and it was in Canada this past summer. And as a result of that, apparently, according to the complaint here, there's been, there's been threats of, and there's been some retaliation as far as from the chief officers. The chief officers, Curt, that was
chiefs. I would just call it the administration of the airport fire authority. Yeah.
Is just really appears to be very heavy-handed towards the members that kind of went up there and had this resolution passed. And what they're seeking to do is basically look for an injunction to prevent these types of activities from continuing to occur or occurring in the future, based upon the information that the local union folks are getting as far as what's coming down the road, as far as ramifications from them taking that symbolic gesture. There's nothing attached to it other than the symbolism of, like you said, I would, if I'm fortunate enough to be fire chief someday, I'm not going to want to have a censure, but at the end of the day, it's not, it's just more of a, I would rather not have that. That's why hopefully your actions are such that you won't find yourself in that type of situation. Like I said, I don't think it's something that's done lightly by the folks on the international or the local level. Yeah.
Well, I think if you're in an IAFF local, you're probably familiar with the term censure, because it does come up from time to time. But folks who are not in the IAFF, and maybe whether it's a department that doesn't have a union or jurisdiction that doesn't recognize collective bargaining, or a combination department that doesn't have a union, or a volunteer organization, or attorneys, or whoever may be listening. The censure is really, and you said it's symbolic more than anything else. It's just a statement from the IAFF of displeasure, I guess you could say, with the way that the administration is treating the firefighters, treating the members of the collective bargaining unit. So it's symbolic. It has no significance beyond, I suppose, if you're looking for a new job, it may be considered something that you will go with you, that you have been censured in the past. But again, my experience, I've never been to that particular IAFF convention. I've been to the Redmond. I've been to a number of Redmond symposiums, which, for those of you who aren't familiar with the IAFF, every other year they either have their health and safety symposium, or they have their what do they call it?
Is it the HR? Isn't it is Redmond HR?
No, Redmond is the safety. Redmond is the safety.
I'm sorry. Okay.
Safety.
I got him.
Yeah.
Okay.
But one year they have the Redmond, the next year they have this conference, which is their you call it biannual.
Oh, biannual. Yeah, the convention. Yeah. I think that's biannual, where you have your articles, and then they
Yeah.
Yeah.
So it's every other
Eventually.
year, but they actually vote to censure certain people. And again, the details, I've put a lot of the information in there about some of the things that have happened. And I'm sure there's another side to all of it as well. Point being, I think it's interesting to understand what a censure is and how it relates, how one goes about finding themselves censured. And in this case, the chiefs who were involved and the airport administration appears to not be happy with the process and threatening retaliation against the officers. Now, the officers of the union. Now, one of the other aspects, I'm going to kind of stump the stars here, Bill, with this one. What other options would a union have in this situation to deal with the threat that is posed by retaliation for engaging in union activities?
Oh, like on a state level, ULP type of a thing, like a state
and
level.
You and I just use the word like ICS.
Oh.
Okay, but ULP being
unfair labor practice.
Unfair labor practice. Yeah.
And I think the local jurisdiction is, as far as like in Rhode Island, there's a labor relations board. In Massachusetts, there's a similar type of a body that's, administrative handle type of thing.
Right. So now one of the challenges where I think in most states, they would be able to go to the state labor board. Some of this, at least Dulles, is in Virginia. And I'm not sure Reagan, I thought it was in DC, but is Reagan in?
I don't know.
It's
it's right outside. If it's not in DC, it's on the doorstep. Right, you see, when you go in there, you see everything right there.
Right. But bottom line is Virginia is a relatively new collective bargaining state. I think it's just last few years. I'm not sure if they have their full collective bargaining up and running, but in a state with collective bargaining, you have a state labor board or state labor relations board, and you can file what's called an unfair labor practice with the board. And that's actually a prerequisite to a lot of other things that may follow that. So that would be the normal course of things in a state that has collective bargaining. These firefighters didn't opt to do that. They went right to federal court, and they're seeking an injunction against it. So we'll see how that goes. But
and that raises an interesting question. If you have this labor organization covers these two different entities and possibly in two different states. So I do wonder if there is a jurisdictional issue on the labor board front. Like you said, maybe there is a jurisdictional question. Whereas, we have our rules as far as federal court, diversity, and there's different ways that we federal question, different ways we can get into a federal court. Maybe when you think about that, probably are not many employers or that have folks in the same bargaining unit in different states, so maybe that is part of the.
Yeah, and these folks are the Washington Airports Authority is a municipal or a governmental, well, it's a public agency. So we're not dealing with private entity. If it was private entity, then we'd be dealing with the National Labor Relations Board. They could file an unfair labor practice with the National Labor Relations Board. But here it's a governmental authority, and there is that question. And I'm not sure. I'm sure DC must have a labor board. It's got to be some sort of a labor board for the District of Columbia, but they may not have jurisdiction in Virginia over this as well. So
all depend how it's written. How it's created.
You think about it. You think about if you're representing this union, perhaps in the collective bargaining agreement, you'd want to indicate which state that you have. Which states is going to govern. So and certainly, I'm sure at the time when the organization was first started, you've got an airport in Virginia. Management is saying, "Oh no, Virginia law applies." Before there was collective bargaining in Virginia.
Absolutely.
So, interesting. So,
absolutely.
All right. Well, that's going to do it for another edition of Fire Law Roundup. We've covered our 5 stories. We actually talked about another one. I would ask you again, please click like, please share, and please subscribe. We're trying to get up to 1,000 subscribers. We're really trying hard. And for those of you who are listening live, Bill and I we're gonna log off here. We're gonna log back on in a few minutes. And Bill's got a few FLSA cases, firefighter overtime and wage and hour type of cases that are really at the forefront of some of the legal challenges that we're facing. So he's going to do that. We're going to do that as a separate vlog. Okay, so that'll do it for another edition of Fire Law Roundup.